welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law. Today we're going to explain Illinois formal proof of will hearing. So we're going to talk about what a formal proof of will hearing is, who has standing to file a formal proof of will hearing, the deadline to file, the purpose of a formal proof of will hearing, and who bears the burden of proof in those sorts of hearings. So let's start with what a formal proof of will hearing is. Formal proof of will hearing is an opportunity for interested parties to challenge the admission of a will into probate by requiring the executor to present proof that the will was properly executed. So it's limited to the evidence regarding execution of the will, and it's different from a will contest, and we'll explain the difference a little bit later. So let's talk about who has standing to file a petition for a formal proof of will hearing. Not anybody can come in and file this. It's got to be an interested party, and an interested party is a heir or legatee. An heir is somebody who, according to state statute, would, in the absence of a will, be entitled to inherit money from the estate. A legatee is someone that's the beneficiary of a will or a trust that the will or trust names as someone entitled to inherit money. So you have to be an heir or legatee to file a formal proof of will hearing. The deadline to file the petition for a formal proof of will hearing is 42 days after the date that the will was admitted to probate. But if you blew this deadline, you may still be able to file a will contest. And again, we'll talk about the difference later. The purpose of a formal proof of will hearing is to require the proponent of the will to produce witnesses that saw the will being executed to prove that the will was properly executed. The court will determine whether there's proof of fraud, forgery, compulsion, or other improper conduct in the execution of the will. Most wills have something called an attestation clause, and it's basically something above the witness's signature where the witness certifies that three things are true. The first is that the witness saw the testator, the person who made the will, sign the will. So the witness witnessed the will being signed by the person who signed it. The witness signed the will in the presence of the testator, and the witness believed that the testator was of sound mind and memory at the time that the will was signed. So for a will to be properly executed, all three of those clauses in the attestation clause have to be true. The witness must have seen the person signing the will. The witness must have also signed the will in the presence of that person. And the witness must have believed the person signing the will to be of sound mind and memory at the time that they signed it. If any of those three things aren't true, then the will isn't valid. So a formal proof of will hearing is usually limited to an investigation of whether these three things are true or not. And the only evidence that's typically presented in a formal proof of will hearing is the testimony of the witnesses to the will. So the executor has to track down the witnesses to the will, and either through deposition, and there's a whole process for obtaining the right to have them testify by deposition, but either through deposition or having them appear in court, they basically have to say, yes, we saw the person sign the will, we signed the will in the presence of this person, and the person who signed the will was of sound mind. So typically it's only the evidence of the testimony of the witnesses that's offered as evidence, but other evidence of fraud, forgery, or compulsion can be offered in this hearing. So let's talk about who bears the burden of proof in a formal proof of will hearing. If there is an attestation clause in the will, then there's a presumption that the will was properly executed. So unless the witnesses actually testify that any of those three statements is not true, then the will is going to be presumed to be valid. If the witnesses are unsure, or they can't remember, or if they provide vague or contradictory responses, then the presumption that that the will is properly executed will hold up if there's an attestation clause. So they have to actually say, no, we didn't sign this will, or no, we didn't see the testator sign the will, or no, I don't think he was, I'm pretty sure he wasn't of sound mind at the time that he signed the will. If they're unsure or vague or have contradictory responses, as long as there's an attestation clause, the will hold up. Let's talk about the difference between a formal proof of will hearing and a will contest. Illinois is a double contest state. It's basically people who are contesting the will have two bites at the apple. The first step is usually to file in Illinois a formal proof of will hearing to challenge the execution of the will. A will contest is different from a formal proof of will hearing because in a will contest, a will can be challenged for a variety of reasons using a variety of different forms of evidence, whereas the formal proof of will hearing is usually just limited to proving up the attestation clause, those three things that have to be true for the will to be valid that we talked about earlier. The will contest can go into fraud, forgery, undue influence, compulsion, state of mind, breach of fiduciary duty. Basically, you can do everything that you would normally do in a formal proof of will hearing, but it's a broader scope that the will contest covers. So usually what people will do if they're trying to challenge the will and they believe it wasn't validly executed is they'll file a formal proof of will hearing, and if the will passes that phase, then they'll subsequently file a will contest. And we've got a great video and article about will contests, and actually a series of them at learn-about-law.com if you want to learn all about will contests. So finally, let's talk about what happens if the formal proof of will hearing ends up with the will being thrown out. So if the challenge to the will is successful in the formal proof of will hearing, the court will deny admission of the will to probate, and the executor will be removed. So the executor will no longer be able to control the assets of the estate and will no longer be able to use the assets of the estate to defend the will after the formal proof of will hearing if the person challenging the will is successful. So thanks so much for listening. We've got lots more great articles, videos, and podcasts at learn-about-law.com in nearly every area of law.
Thanks so much for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week, and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit Making Real Estate Fun for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation.